In today's video, we're talking about one of the most common crimes that we see in Arizona. It's called shoplifting, but more specifically, we're talking about the defenses that are most applicable in shoplifting cases. Our firm, we do criminal defense law. We've represented many people across all four corners of Arizona on these types of cases, and these are the defenses that we see that are most successful. So as a quick reminder, I have another video about shoplifting, specifically the overview on how it works. But if you look at the statute 13-1805, you're going to see it's broken down into two separate sections. You're going to see a part of it that's talking about a culpable mental state. It doesn't say that in the statute, but that's what it's referring to. We're talking about a person's mindset. Did they intend to take the property? Did they knowingly take the property? Was there an intent to deprive somebody else of the property that's in question? That's all about a person's mental state, not the conduct, but what's going on in their head. The other thing that we talk about is the actual specific conduct. So we're talking about the action and the conduct. Was property taken out of the store? Was property put into something else, like a bag, to conceal it? Was property taken out of one package and put into another package? That's all the conduct. So we have the person's state of mind and then the actual conduct that a person engaged in. And there's defenses that are based around both those. So let's dive into it. What are some issues with a mental state? So the statute says specifically that the property needs to have been taken knowingly. Did a person put it into their purse, into a bag? Did they do that intentionally? Did they do it knowingly? Or was it done sort of haphazardly? Was it instinctive? Was it involuntary? Did somebody else put it in their property? Did they grab somebody else's cart? Was there just a mistake here where the person's mental state was not saying, I am knowingly taking that property that doesn't belong to me? Or was it something more inadvertent? Does this standard, and this is a legal term, does the knowing component of this mental state, has that been met under the facts of the case? If there's arguments to be made to that effect, it's a very concrete and effective type of defense. Same with this. Did the person take that property with the intent at the time that they were taking it to deprive the other entity of the property? So in other words, did a person take that and put that in their pocket with the intent to deprive the store of it? Or were they going to take it out of their pocket when they went up to the cash register and pay for it? Sometimes people have too much stuff in their hands. They will put things in different places, but they have every intention of actually paying for it. They may have been stopped before they were able to complete that portion of the transaction. And so you have to be clear about that. Was their intent to deprive the other person of the property? That can be a big defense. If there was no intent, or during the interview with the person who has stopped or arrested, if they can show or they fail to show that there was intent at the time, that may be a good defense as well. Let's move on to action or conduct. So if you look at the statute 13-1805, you'll see that there are a number of different elements or different types of conduct that are criminalized. And so the big deal that we see screwed up a lot is that sometimes loss prevention officers will actually make mistake. So I have here LPOs make mistakes. They do. They will sometimes categorize a person's conduct in a way that doesn't fall within the specifics of the statute. They'll say that it falls within the purview of the statute, but when you look through it, when you get security footage or when you listen to interviews, the conduct doesn't fall within one of those prohibited elements, one of those prohibited subsections. And if it doesn't fall within one of those, it's not shoplifting. It has to be specific to the statute. Just because it might feel like shoplifting doesn't mean it's shoplifting. The law is the law for a reason. It's as black and white as our legislators can muster up. But the fact is it needs to fall within one of those elements. If it doesn't, it's not going to be shoplifting. The other thing that is important is sometimes there's an alternative explanation for it. So we have seen this on numerous occasions, but I have written here, what if somebody leaves the store to go and buy something outside? So we had a situation, we actually have had this multiple times, where somebody will go into a store, they will grab a basket, they'll put some stuff in the basket, they'll think, I want to go buy the plants that are outside the front, or the bird feeder that's right outside the front of the store. We see this a lot around Arizona at Fry's or Albertsons. They have plants, Trader Joe's, Sprouts, all these different things. They've got stuff that are outside of the store. So somebody will go into the store, they'll get a couple groceries. On their way out, they will say, I want to go get that cactus or that plant or whatever. They'll pop right outside the front of the store. Boom, they get arrested or stopped by a loss prevention officer for shoplifting. Well, They had no intent to actually leave the store without paying. They just crossed a boundary. And so a loss prevention officer will say, that kind of felt like shoplifting, but it really wasn't. There's an alternative explanation here. They were going outside to pick up something that was outside the store, to take it back inside, to go to the cash register and purchase it. So there's an alternative explanation here. If there's one of those in your case, that might be a strong defense. The other thing that we see that's quite common in these types of cases are the witness availability issues. So loss prevention officers, that's essentially their job. Now, these aren't typically law enforcement, they're not sanctioned police officers or things. They're people who are hired by the private companies to act as loss prevention officers. And so there are situations where that person is no longer employed with the store anymore. So, misdemeanor cases, they can take 3 to 4 to 5 to 6 months sometimes. And 6 months from now, from the date of the violation, is that person still around? Are they still going to show up in court? Are they still going to come in and testify? That's a big problem. If they can't come in and testify, they may have admissibility problems. They may not have anybody to come in and say that X did this, X took this person did this, because they're not around anymore. So what if the witness is not there? It may be a case that has to be dismissed. Also, if that person's not around, we also want to look at other evidentiary issues. Can they get the surveillance footage admitted? Can they get any audio recordings admitted? How do you get this stuff in front of a judge or a jury to have them consider it? Just because they have it in their possession, meaning they have some audio recordings or some video recordings, doesn't mean that they can just bring whatever they want in front of the court. They have to lay a foundation for it in order to get it put on a big screen or presented to a jury or a judge. They need to go through certain disclosure requirements, and there are situations where they can't lay a proper foundation for that type of evidence, and they cannot get it admitted. And so if that evidence can't come in against you, their case is a lot weaker than it should be. So those are a couple things that we can do to attack the conduct. A lot of the times, especially for first offense shoplifting charges, these types of cases are resolved with reductions or with what is called diversion. So a lot of city courts will offer programs where if somebody who has no criminal record, they've never been convicted before of a shoplifting, if they take some classes like an adult responsibility class, something, it's on a city by city basis, they have their own programs for shoplifting. But in exchange for taking that program, completing that class, doing some community service, paying some restitution, they'll turn around and dismiss the charge. So that's a lot more common than some people might think. A lot of the city courts have programs like that. Some of them don't offer it automatically. You have to kind of push them to give it, to give that to you. They want to get the opinions of the loss prevention officer or the store, whatever, whoever is involved in the case. They need to get their authority to approve it. But it's not a bad resolution because it does dismiss the charge. You want to make sure that you avoid having shoplifting on your record. Employers or anybody doing background checks tend to think that that is a crime that shows dishonesty or integrity problems. So you want to do what you can to dismiss it. So if that means taking a class, sometimes that's not a bad option. And then, of course, if somebody does have a history of prior shoplifting convictions, you want to make sure that you're doing what you can to get those off the record, get those out of a person's history so that they're not coming in. How can you eliminate the priors or show that those priors shouldn't be used against that individual? In this case, that can really mitigate the consequences of a shoplifting conviction. If prosecutors see multiple convictions for it, they will want to start tacking on a substantial amount of jail time and those types of things. So you want to mitigate that as much as possible. So I hope this helps. If you've been charged with shoplifting, somebody you love, somebody you're watching this video on behalf of has been charged with shoplifting, this is just a small sampling of some of the defenses that we can use. There is a lot we can do to help people through these situations. So give our office a call. We offer free case evaluations. We'll have you come in, we'll sit down, we'll review the facts of your case, make sure you have a good plan and a good strategy to ensure that this does not end up on your record. Give us a call. We look forward to speaking with you soon. Thanks for watching.